Welcome back to the Data Protection Diaries. In today's video, we are going to be talking specifically about contracts, and in particular, contracts with third parties or data processors, service providers, anybody that is working on your behalf, and in particular, organizations that are hosting, processing, collecting, manipulating, doing anything with your organization's data. As always, if you are new to the channel, please do make sure that you subscribe. I've been informed that there is like a little bell, which is apparently a notification thing. Make sure you hit the notification bell and you will be notified when a video comes available. Obviously, if you enjoy these videos or you find them useful, please do like the video as well and comment down below if you've got anything to add to the conversation. It all helps to just show YouTube that this stuff is interesting, and then it shows it to other people who may well be interested. So that is much appreciated. Anyway, enough of the waffle, let's get on with what we want to talk about today. So most of you watching this will either already know or will have an idea of the obligations of a data controller to have a contract in place with any kind of data processor, all covered under Article 28 of the GDPR. What I don't want to do today is specifically talk about the detail of those contracts or the detail of those contracts under the terms of the regulation, because that's not what this is about, and that information is quite widely available if you want to gain access to it. What I want to talk about is a very particular issue that people tend to neglect, shall we say, when they're dealing with contracts and when they're looking at contracts, especially contracts with larger, more multinational organizations, shall we say, people with more clout than the average. A discussion that was going on LinkedIn the other day, I hope nobody minds me using this, but I think it's really interesting, and it's actually something that in my career I have seen happen a number of times. So very often when you are looking to appoint a processor, when you're looking to appoint a service provider, people concentrate on obviously the technical aspects of the contract. How is information going to be protected? What controls are in place? What access rights? How easy is it to gain access to the information? How will SARS be dealt with? How will incidents be responded to? Obviously, the commercials, SLAs, all of those sorts of things are very, very important and obviously need to be addressed in any kind of agreement or contract. The thing that people, in my experience, and I'm not saying this happens all of the time, so I'm always very conscious of that, in my experience, the thing that organizations and people tend to neglect is the exit provision and the exit terms of those agreements. Now, I'm not talking about the commercial exit terms, so I'm not talking about paying out of a contract before the end of its time, or trying to release IP. What I'm talking about is what happens to the information that these systems have consumed during the period with which they have been under contract. Now, I have seen in organizations where they have been instructed to collect information over a 20-year period, and obviously for whatever reason the organisation has decided to move away from this particular service provider to a new service provider. I think that the simplistic side of that would be to say, I would now like my information back because I'd like to go and put it into a new system. Now, in an idealistic world, the organisation would say, of course, no problem, here's your information. How would you like me to provide it to you? Let me transfer it to your new provider and be of some assistance. Unfortunately, that is often not the case. They will either say, we are not obligated to provide you that information back at the end of the contract. There is no agreement in place to carry out this task. It is going to cost X amount of money and you need to pay for that above and beyond the service that you have been paying for. In some instances, they will provide a file format that is proprietary to the system that you've been using. So let's say it's a SQL-based database. So they may go, here is a SQL database file, or here's a plain text file, or here's a data dump of some kind, and they just provide that information to you and they say, well, there you go, there's your information, ingest it how you will, do whatever you want to do with it. Organizations, that causes huge problems because they don't have the ability to ingest that information. They don't have the technology, the resources, the skills in-house to understand how a SQL database works, or to read it, or to get that information from that file into their new system. So you are left with the very real risk that you now no longer have access to that information, and there is a risk to your organization because you may need it for regulatory purposes, you may need it because financial reporting purposes. There could be any number of reasons. What you're going to end up doing is trying to wrangle, negotiate, discuss with the service provider and try and get them to see your point of view. What generally happens here is that they will go back to the contract, they will look at the termination provisions of that contract, and pretty much in 9 out of 10 instances it will say at the end of the agreement, we will provide you back with any information that you need or that you see fit, and everything else will be deleted. And when they say delete, they mean delete. They're not going to keep it for you, they're not going to maintain a record of it for you. They are done, their contract is finished, they are going to cut it off and they are going to get rid of that information. So it's so important when you are negotiating contracts, especially when you are using somebody to provide you with support services or processing, that you stipulate within that agreement what you want to happen to the data at the end of that contract, how you want that data to be provided to you, and agree what costs there may be associated with that. Because if you get to the end of the contract and you haven't agreed it, they are going to have you over a barrel. You're going to have no choice but to either pay the extortionate fee that they want to charge, or accept that your information is gone forever, or in many cases, and many cases that I have seen, decide not to move away from that particular service provider because the cost benefits that you thought you were going to realize from changing your monthly costs or your monthly user base is lost by the fact that it's going to cost you tens of thousands of pounds to actually extract the information that you need to be able to utilize the new system. So you just stay where you are. And this is the way that it happens with all service providers, but it is something that I have seen a lot. And the best way to do that is to make sure that you are protecting yourself in those exit provisions of your contracts and your agreements. This is all very well said and done for new contracts, and I appreciate that. If you've had a service provider for 10 years, then obviously you're probably not even going to have the requirements that you need under the regulation anyway, so maybe now is a good time to go back and review those contracts. But the key thing here is that at some point you are going to have to make a risk-based decision or a commercial-based decision that may well say this service provider, although they look brilliant, is not the company for us if we cannot get our information out in an effective way at the end of this particular service. And you may just have to make the call that if you are using a large corporate entity that is not going to change their policy, is not going to change their standard terms and conditions, that you just have to accept that you are either going to be stuck with them for a long period of time, or you're going to have a long transitional period where you transfer information across manually, or you start to swap over systems manually. But these are all things that really should be considered at the point when you're looking at taking on a particular piece of software, or you're looking at taking on a service from a new provider. As always, I feel like we've just sort of flowed into this. I think there's a lot more detail that can be covered on this. If that is of interest, please do let me know down in the comments below, and I'm happy to go into a bit more detail and cover some of that off. But for now, the advice, my opinion, my view, not my advice, is to look at the exit provisions of your contracts and just make sure you are comfortable that at the end of those contracts you can get your information back out because you do not want to get to the end and realise that it's not going to be possible. If you like this video, please do give us a thumbs up, subscribe to the channel, hit that notification bell as well, and we very much look forward to talking to you again soon. Thanks very much.